Are we going to see tons of changes in employment law? I kind of think we will, from the perspective of we're going to see more claims filed than we normally would have. Now, is it going to result in bad findings in front of judges and juries? I think that's kind of to be seen.
Good morning, HR. I'm Mike Coffey, president of Imperative, bulletproof background checks with fast and friendly service. And this is the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. The last Thursday in April means it's time to look at a few HR topics and the news and social media over the past month. And joining me to do that is Adam Dougherty. Adam is a shareholder in the Dallas office of Ogletree Deakins and is board certified in labor and employment law by the Texas Board of Legal Specialization. Adam counsels employers from across the country in cutting-edge and high-stakes employment matters and, when all else fails, represents them in state and federal courts and before federal and state agencies. Adam is also active in his local SHRM chapter, Dallas HR. Always want to give the local chapters a shout-out. Welcome to Good Morning HR, Adam, and sorry for butchering your last name.
That's all right, Mike. I appreciate it. Happens all the time. So I pronounce my last name differently on any given day, as well as every member of my family. So no problem there.
Everybody can say my name right, but they all spell it like the drink. So I've, and my parents gave me the first initials MR. So when I was in aerospace, my badge actually said Mr. Coffey on it. So I lived with that. So let's start with the social media story from this month that we chose. On the Improve Your HR Facebook group, that's Suzanne Lucas's Evil HR Lady group, a frustrated HR pro posted, about seeking advice about a situation that a lot of us have faced. An employee was put on a performance improvement plan, didn't improve performance, and was ultimately terminated. And then the emails and the text and the phone calls started. First, I guess, to frontline supervisor and HR. And the HR professional, I think he handled it pretty well in dealing with the applicant or the employee, and said, look, okay, because the guy was threatening lawsuits and I'm going to sue you. We've all heard those. Okay, well, if you're going to do that, then have your attorney contact us. There's no reason for you and I to talk at this point. The decision's made. And he told the rest of his team, cut off contact, send anything you get to me. And then, of course, the emails start to the CEO and other officers and other people in the company. And the best he, could do, I think, is handled it pretty well as far as just telling people to send all that information to me. Let's not engage. But I guess the first question, is there anything you think an employer can do to avoid that kind of situation when somebody is just not happy with let's say, a legitimate employment decision?
It's very tricky, right? Because especially in this day and age, after, we'll just say President Biden's NLRB, especially if the person's a non-supervisor, they really have a lot of power, we'll say, in how they can communicate with the employer. And it's very difficult to push back to stop the complaints for fear of creating some sort of claim with the NLRB or setting them up for a retaliation claim. We're still kind of waiting to see how Trump's NLRB is going to play out, on whether the employer is going to get more power to push back or they have less concern of creating claims for the employee. But I think overall, you kind of summarized it, and I think in a good way. I think the HR person did a good job. At the end of the day, what you want to be very clear on is that what I would say is, direct all the communications to me. And maybe it's your HR director. Maybe if you have an in-house attorney, that's who I would direct it to first. And then even if you have outside counsel, it might be a good time to retain outside counsel. So you kind of have that one step removed beyond the company. I send those emails a lot where you reach out to the employee, especially if the employee has been terminated, and say, hey, company has retained me, direct all future communications to me. And then you're putting the individual on notice. Everybody else is closed off. Don't email them. And if you do, there could be potential ramifications. What I also instruct routinely clients to do, if the employee is harassing them, if you've not gotten outside counsel to help, is there is a block button on your email And so you certainly can block the person so that none of the emails are coming through, or maybe they're going to go to spam. I think that's a good thing to do. I would also, if you do that, make sure you're saving the emails that the individual is sending, because I think it could potentially be used against them if they do file a claim. Not that it's necessarily a defense to a discrimination claim, but a lot of times we're telling stories about the defenses, and if the person is being unreasonable with the number of emails they're sending to the company where it's effectively harassment, I think that paints a good picture maybe to the EOC or to a judge and jury that this person's really not acting reasonably.
Well, and I've seen cases where the emails and the communications make one claim, and then by the time the plaintiff's lawyers have gotten hold of it, it's a completely different claim, and maybe it's even contradictory to what they were, you've got in writing from them claiming or admitting sometimes. So when you hear that this former employee is going to file litigation, my gut instinct is always, this is where we send it to counsel, right? I mean, if you've got employment liability insurance, turn it over to your carrier, let them run with it. And at what point is just saying, I'm going to sue you. I've talked to a lawyer and he says, I've got a case, and so I'm going to sue you if you don't do this. Is that enough to turn it over to outside counsel or to your insurance carrier?
Well, I think so. I'm not an insurance attorney by trade, so I'm not necessarily sure when the obligation kicks in. I think it's kind of policy specific. But I think when somebody's saying that, it's always a good time to do that. And you should take them seriously. Although I'll add a couple of thoughts on that. One that's happened recently over the last 2 or 3 weeks, where, get the first email from the individual, I made an appearance, and then you're like, man, this individual is responding very quickly to my emails with a lot of legalese in there. So either this person, unknown to anybody, has a lot of legal training, or in the past it used to be maybe they have an uncle or a cousin who's an attorney who's dabbling in it. In the couple of situations recently, what became very clear by the third email, where you're like, there's something just off about this. And they're citing to 2 potential claims, and then the last 2 make no sense whatsoever.
ChatGPT, right?
ChatGPT, yeah. So that's been very eye-opening. My colleagues here at the firm, everybody has experienced that, and for some reason it just hadn't arisen in my practice, but I've seen that 2 or 3 times, definitely. And clearly when they're using that ChatGPT, especially if it's coming from the individual, like you were mentioning earlier, that all becomes evidence, right, on how they're viewing your claims. They're almost opening the door. You can see how the deposition's going to go, where you can cross-examine them for that. So that's kind of my first thought. And then secondly, whenever somebody puts out there, oh, I've talked to an attorney, I've filed an EOC charge, I would say in my practice about half the time, the employee hasn't done that. And half the time, we don't see a letter from an attorney. We don't see a charge from the EOC. And I think employees are educated enough now where either through ChatGPT or just Googling, that they know by putting that out there, it's raising the stakes, it's getting outside counsel involved, and they might even know, okay, yeah, the company, if they have EPLI, they're going to get insurance counsel involved. So they kind of know the buzzwords to put out there to ratchet up the claim. But I always take them at their face value. And something to consider when you get that email is to issue a litigation hold. And a litigation hold is simply a document. We draft them all the time. And it's basically saying to the people that have relevant knowledge and especially relevant documents, hey, don't delete that stuff. Save them for the potential litigation. And so it serves to protect the company in case somebody inadvertently or maybe even intentionally somewhere in the organization deletes potentially relevant documents. But I think more importantly, with turnover these days, if you're collecting all the relevant documents, it's good to have them in one spot, especially the ex-employees' emails. If they're making claims, I would save all their emails. Especially, I do a lot of non-compete work, and a lot of times those kind of overlap with the claims of discrimination. Maybe they're going to a competitor for the new job. Issue that litigation hold, take an image of the person's email, because I'm always surprised. It's almost like employees can't help themselves. And it might not be when they give their 2 weeks notice, but 1 or 2 minutes before they're actually out the door, they download that customer list or they send it to their Gmail. And by imaging the computer, maybe you don't ever need to use that information, but it's good to have it there in case you do.
And so that litigation hold, I mean, it's going to go to your IT department to make sure that they're capturing stuff, that somebody who knows how to really image that drive without altering any information and putting their own fingerprints on it can do that. The hiring manager, anybody who's received crazy emails from this person, and if they're coming into you, like you said, either block them and they're going to get trapped someplace in your filters or someplace, or what I've suggested is just create a rule in your Outlook. So, or, that you just puts it in a folder, crazy number 3, and it just, everything goes into that folder. You don't even have to look at them, but they're all piling up in there. But then also, like you said, I guess time clock, if it's a time clock employee or somebody like that, any of those records, just whatever claims they may come up with later, plus those performance records. If it was on a PIP and they just really didn't, perform and come up to level. Now, when they're making kind of threatening, not just I'm going to threaten a lawsuit, but, something short of I'm going to kill you and your dog, but, something that's, makes people feel uncomfortable. At what point do you start to look at other actions to maybe protect the organization or people or involve law enforcement, things like that? What are those calibers?
Yeah, when it comes to that, I really take the employee at face value. If they're truly using threatening language, then there are several options open. We always do a cease and desist letter, putting them on notice that their harassment has gone beyond that to where we're feeling unsafe, basically creating a record of it. And then if the situation warrants, you can certainly go to your local police department. You could also go to court and get a temporary restraining order. But in this day and age, as we all know, I take them very seriously. And I always make sure that the client's, person who's in charge of security is aware of those emails. And it could be, maybe they don't even have a head of security, but they're in a big building. Okay, let the building security know. If you have a photo, maybe share the photo. Take the necessary steps to protect yourself and your employees. And as we know, 9 times out of 10, if not more, nothing's going to happen from it. But obviously, there are those occasions. So God forbid something does happen. From that type of liability, you want to create a record that you took it seriously and you took the necessary steps.
And if obviously if the employee is owed anything, if you've got payday law requirements or anything, meet all of those too. I mean, you just, treat them like a departing employee as far as all your obligations, I guess, just to make sure we've checked our boxes and then maybe go back and review the PIP and do everything. Just, did we do this right? Is there anything, is there anything we ought to document that we went back and looked at, things like that? I don't want us to get into second guessing ourselves, but it seems like it may be prudent if somebody makes a claim and they're that upset about it, that maybe a fresh set of eyes or a fresh perspective look at it and just say, did we treat this person fairly?
Yeah, you actually took the words out of my mouth for my last point on this subject. I was going to say exactly that. I do a ton of advice and counseling, and I would say 75% of the time we're typically consulted before the termination, but it's not unusual to get called for the first time after the fact. And in those situations, it's usually after the company and the ex-employee have exchanged a couple of emails, and maybe the ex-employee raises something new that might have some validity to it. Or maybe the client is just losing a little bit of sleep. Hey, did we handle this correctly? And we kind of come in and just do, kind of give it a second glance. And sometimes, although it's rare, it could be, maybe you didn't handle this the best. But a lot of times it's, no, you handled it okay. And then how can we start to create our defenses to make them even stronger? And it could be, okay, let's say, who's the potential comparator that they might compare themselves to? Okay, it's another employee over there. Well, let's get their performance records. Let's review them. Let's save them too. because it'll probably help in our defense to show that we treated the individual fairly.
So you're preparing that potential case and
Exactly.
making sure it's not just litigation hold on stuff related to that employee. It's let's collect everything else too that we may need to help, that may help us defend our decisions later.
Exactly.
And then obviously there's always, performance improvement plans are often seen as just a way, as the final step to get rid of an employee. And I don't think most employers use them that way, but that's certainly how employees feel when they're that they never, especially when they're terminated, well, they have a set up to fail. So always reviewing those plans, making sure your supervisors and your frontline leaders know how to use them and they're giving the right feedback. It's, how do you get to the point where, how do you avoid even having to get to that point? How do you coach and incentivize and build a team so that people, can be successful in the role? We're not talking about behavior here. We're talking about performance and we, how do we build those skills? Any last thoughts on that side?
Yeah, on the PIPs, I think PIPs are generally a good thing, but just like all documentation, it can kind of come back to haunt you. And, a lot of times we'll see the PIPs where you kind of touched on it, where it's like, okay, after the first 3 weeks, we'll have a in-person coaching session at 12 o'clock in the supervisor's office. And, we get called in, maybe the EOC's charge has been filed, and we say, okay, well, tell me about the meeting that you put in the PIP and said was going to happen on this date. Oh, well, it didn't happen. Supervisor was on vacation. They called in sick. They were too busy. Okay, well, yeah, did you reschedule it for another time? No, we never got around to it. It doesn't mean that there's discrimination that happened. But, like I mentioned, employment law a lot of times is just telling a better story than the other side. And when you have stuff like that, you're just kind of tilting the balance of the story, being a little bit more persuasive from the ex-employee when you kind of miss the low-hanging fruit like that.
And let's take a quick break. Good Morning HR is brought to you by Imperative, bulletproof background checks with fast and friendly service. If you're an HRCI or SHRM certified professional, this episode of Good Morning HR has been pre-approved for 1/2 hour of recertification credit. To obtain the recertification information, visit goodmorninghr.com and click on Recert Credits. Then select episode 197 and enter the keyword lawsuit. That's LAWSUIT. And if you're looking for even more recertification credit, check out the webinars page at imperativeinfo.com. And now back to my conversation with Adam Dougherty. Well, and speaking of PIPs, there was a Bloomberg law article this month that kind of caught me by surprise because there was a Supreme Court decision last year, Muldrow versus City of St. Louis, and I just totally missed it until I saw this article. And really, I think probably most people at the time weren't thinking about what its bigger implications were. But maybe you want to get into the Muldrow. That's I'm gonna mispronounce that lady's name as much as I do yours, but maybe you want to get into that decision and what it meant, and then how it's being expanded by some of these plaintiffs' lawyers.
Yeah, very interesting decision. Very interesting from the context too. It was the U.S. Supreme Court, and as we know, the U.S. Supreme Court is conservative, right? There's a conservative majority there. And I think when you look at this decision, you might think, man, that's more of a pro-employee, more type of liberal decision you might expect from a Democrat-controlled U.S. Supreme Court. But to kind of date myself, I remember one of the first pieces of advice I got like 25 years ago when I was, we call them baby attorneys, was talking about this type of very issue. And, the question is, I think we all kind of know, like, an adverse employment action is kind of the legal term of art. Well, certainly like terminations, adverse employment action, failure to hire, adverse employment action. But it's what about the in-betweens? And that's what this decision talks about 25 years later. But the first example I got when I started practicing employment law was, what if you move somebody's really nice parking spot on the bottom level right next to the office, 5 levels down in the dark part, and let's say you did it because of a protected category. Well, back in the day, it was like, well, that's not maybe ethical or moral, discriminatory, but doesn't rise to the level of something you could sue under Title VII. Now, I don't know that this Muldrow decision goes that far necessarily, but it certainly moves the needle closer to that than what it was. And so, again, the kind of term of art is adverse employment decision. We have a number of federal appellate courts, and that above them is the U.S. Supreme Court. And so where the U.S. Supreme Court chimes in or feels compelled to issue rulings is when you have competing decisions in the federal appellate courts. So here, what does an adverse employment action mean? Well, a lot of the federal appellate courts had different interpretations of what that phrase means, because the phrase isn't, adverse employment action. And as you might expect, the more conservative areas like the Fifth Circuit had more pro-employer interpretations of that, where California, the Ninth Circuit, had more pro-employees. So in the Fifth Circuit, we kind of called it an ultimate employment action. Well, the facts of Muldrow are pretty interesting. And so I'll go through them really quickly. And keep in mind, we had a Fifth Circuit decision, which is here in Texas, that ruled similarly from the perspective of defining what is an adverse employment action. Interestingly, it also involved this Fifth Circuit decision, a police department here in Texas. The Muldrow decision at the Supreme Court involved a police department from the city of St. Louis in Missouri. And basically in Muldrow, kind of like the decision here in Texas, you had a female police officer. She was a plainclothes officer who worked in a specialized intelligence division in the St. Louis Police Department. And she was transferred to a uniformed neighborhood patrol position. So specialized, kind of undercover, I see it, to cop walking the beat. Mm-hmm. Interestingly, same rank and the same pay. So kind of how we viewed it from a Texas perspective, that was always maybe the deciding factor. Okay, the job duties are a little bit different, but you're getting the same pay and same rank. Is that really an adverse employment action if we're just changing your duties?
Right.
And that was kind of the question here. Some of the key differences that the Supreme Court focused on, she moved from a regular Monday through Friday schedule to a rotating schedule that also included some weekend shifts. So if you think about that, well, that's, something
that's more material, right?
More material, yeah. And that's a great way to describe it. She also lost access to an unmarked take-home vehicle that she could use outside of work. The other thing she specifically said, so her testimony, she went from a more prestigious position to a less prestigious one. And then she also claimed that it took away opportunities for her to work on kind of high-profile, more important cases. And then it took away from her ability to network with kind of more important people in the police department, which could reduce her opportunities for promotion and to network and kind of grow her career. Interestingly, just like the Fifth Circuit decision, it was basically put into the record that part of the reason why they moved her was because the role that she was previously in was dangerous and perhaps better suited for a man.
Ooh.
Yeah, same thing happened in the Fifth Circuit. And I think that's a very telling, important fact here, right? And a lot of times you don't see that in our type of work in discrimination cases. It's usually circumstantial evidence, not really something as direct as, hey, we're moving this, now it's for your safety, but it also relates to your sex or gender. So I think that's a very important fact, but in of itself wasn't necessarily material to the decision itself. The court didn't necessarily say this is why we're ruling that way. Interestingly, the judges themselves kind of had different takes on what becomes material for an adverse employment action. Justice Thomas said it needs to be, quote unquote, more than a trifling harm. So in a way, you're taking a vague phrase and using more vague words to describe
exactly.
it, right? Justice Alito, he wrote a concurrence, so he wasn't in the majority. He basically said, I still have, he's like, I agree with what they're saying. A discriminatory adverse employment action can be less than termination. But the way the majority is describing it, I'm still as confused as ever on what it is. And then Justice Kavanaugh, he basically said the same thing. He kind of said discrimination in and of itself is the harm. And he basically said, what the majority is saying is there has to be some harm. And he basically said that seems to be such a low bar that it's going to be satisfied almost all the time. And so the Supreme Court, kind of the way our judicial system works, that's kind of what they put out there. The adverse employment action needs to be some type of harm, and we'll kind of know it when we see it. So it's kind of out there now, and we're going to see how courts interpret that phrase. How are courts going to interpret the phrase? Individuals are going to file EOC charges. Some of those are going to lead to litigation covering this, and then we're going to get more opinions from the district court level back to the appellate level, and that's how this is going to play out. Are we going to see tons of changes in employment law? I kind of think we will, from the perspective of we're going to see more claims filed than we normally would have. Now, is it going to result in bad findings in front of judges and juries? I think that's kind of to be seen.
Well, they still have to demonstrate, that there was an underlying bias reason. So,
Correct.
but some of these cases that have been filed were like unreasonable performance demands. Like, we're expecting you to perform at this level. And there's claims that that's because of discrimination, or being put on a PIP could be considered discrimination under this. And there's a complaint like that after making a harassment claim, which is always a little bit makes me nervous when, you have to manage that employee and they have to follow the policies. But it seems like there are some managers who always, after, the employee has made a complaint, suddenly now, their performance isn't meeting our
Right.
standards. And now we're going to start documenting. Maybe it never did all along, but now I'm mad at them, or they're not part of the club. And so I'm going to manage them harder. Or like in this case, just putting, changing this person's role. And the other thing kind of that ties in with what she said was, that loss of esteem or position or, that profile in the department would hurt her over time because of this. And she was saying it was based on her gender and really in kind of, I guess, some of the information in the case suggests that's the case. But they still have to prove. In her case, I think it is a little easier, but how employees always feel that when things don't go their way, that they were treated unfairly, right? And so, and some of them who have a protected class to rely on will lay on that and say, well, it was because of this or that, or this one manager 3 years ago said this one thing to me, and now they're taking this action against me, so it's discrimination.
Yeah, and kind of a more concrete example here in the Fifth Circuit. We've always viewed performance improvement plans, annual reviews, as in and of themselves, those weren't the type of things that rose to the level of being an adverse employment action. And so because of that, employers obviously took them seriously, but they weren't necessarily drafting them with the fear that in and of itself that was going to lead to a discrimination claim. So the Supreme Court decision in and of itself stopped short of saying, no, PIPs in and of themselves can be discriminatory, but I think it's kind of an open question. See how that plays out. So I think a big takeaway from this is that with the smaller type things, in quotes, like PIPs, like suspensions, putting somebody on unpaid leave, that's where I think companies really need to analyze, are we handling this the correct way? Are we treating, your similarly situated comparators, which is typically how most discrimination claims play out? In other words, how are we treating similarly situated employees? Are we treating them the same? And that could go to giving somebody a PIP. Are we putting something in the performance review that could be taken out of context and used against us with this type of lower threshold that's there? So I think from that perspective, it's going to force managers HR folks and internal counsel to really check all the boxes, cross all their T's and dot all their I's, because in a sense, the price of poker has gone up. And where companies are going to see these arise and really have a real effect is, we file motions to dismiss, we file motions for summary judgment. Well, what the Supreme Court is basically saying, and we would file those saying, hey, these things that happen don't rise to the level of adverse employment action. What the Supreme Court is telegraphing is, no, that's usually not going to be the way employers win now. We're actually going to have to go behind all the decisions and look at it from a factual perspective where we're analyzing each decision. And so from that perspective, see it all the time, document, especially if somebody's filed some sort of internal complaint where they're referencing discrimination. Hopefully you were documenting before the complaint if there were performance issues, but then certainly afterwards, you need to make sure you're documenting them as well, which then goes into over-documenting, and that's sometimes can be just as bad. So it definitely this decision creates a lot more risk. And I think the big takeaway is make sure you're checking all the boxes, cross your T's, dot your I's, because this case makes it a lot easier for employees to survive a motion to dismiss, survive a motion for summary judgment, so could create more trials at the end of the day.
And the background side of my business, we're always dealing with the Fair Credit Reporting Act, right? And there's adverse action requirements there before you take an adverse employment action. You've got to, give a copy of the report, consumer report and their rights to the consumer and all of that. And that's the question for 30 years now I've received from employers. Well, what is that? What's an adverse employment action? And my answer's always been, because it doesn't cost you anything to give them a copy of the report. Treat anything that from the point of view of an upset applicant could be construed as an adverse adverse employment action. Just treat it like one. Prepare for that claim. And so give them, under the FCRA, just give them a copy of their report, their rights under the law. And then if you had a conversation with them, document about what they said, and follow the rest of the EEOC's guidance and everything else and the adverse action process if you take action ultimately. But just assume if they're unhappy with this, right? If this is going to be something that they're not going to like, let's just assume it's an adverse employment action as far as how we document things and how we treat the employee going forward. Would you transfer that over to this Muldrow decision then?
Yeah. That's great advice. Great advice, Mike. Yeah, without a doubt.
My 5 years of watching Law and Order paid off. So, well, that's all the time we have today. Well, we covered 2 topics, but thank you, Adam, for joining me.
You're welcome. I really enjoyed it. Thank you for having me.
And thank you for listening. If you enjoyed this episode, please write us a review on Apple Podcasts, Spotify, YouTube, or wherever you're listening, and share this episode on your favorite social media platform. It really does help us find more listeners. And we'd love to hear your thoughts at goodmorninghr.com. Now I want to take a moment of personal privilege. This is the last episode of Good Morning HR to be produced by Rob Upchurch. Rob got us through 198 weekly episodes of this podcast, starting with episode number 1 back in August of 2021. Over the last 3.5 years, Rob's been invaluable in shaping the podcast, working with guests who, besides Adam, never read their emails when we send them, and coaching me on how not to suck quite so hard as a podcast host. He's also become a friend. So Rob, as you move on to bigger and better things, I just want to say thank you one more time and wish you the very best luck. And listeners, I'll see you next week. And until then, be well, do good, and keep your chin up.